Order. The clerk will now proceed to read the order of the day.
Item 1, the Misuse of Drugs Amendment Bill, second reading.
Minister for Home Affairs.
Mr. Speaker, sir, I beg to move that the bill be now read a second time. Last year, there was a parliamentary motion filed by Mr. Christopher D. Souza. It was titled Strengthening Singapore's Fight Against Drugs. I think a number of good observations were made, suggestions on how we can respond to challenges in the fight against drugs, in the drug situation that we are facing. Several members also made good suggestions on how we can improve our approach to rehabilitation, how we can involve families more in the rehabilitation process, and how we can provide better support for abusers after they have been released. There have been changes in the operating environment, feedback from members and stakeholders. We looked at this carefully. We've been analyzing the situation, also looking at the evidence that we have been collecting in our dealings with abusers, both in DRC and post-release. And the current amendments arise from that set of factors. So these amendments to the MDA have two primary focus in broad categories. First, they will enhance our anti-drug framework. They will add some, or they will make some additional actions offenses. They will give some greater enforcement powers. The second part of it, they will give a much greater focus on rehabilitation and move away a little bit from the philosophy of long-term detentions. So if I can deal with the first point first, on the enhancement of the anti-drug framework and the increase in the enforcement powers, we will make some actions, including actions which we will categorize as contamination offenses. There is a range of contaminative behaviors that may not meet the current definition of trafficking or abetment, but they contribute to the spread of drug abuse. And in that way, they harm others. So Clause 3 introduces a new set of offenses which target acts of contamination. So the proposed new Section 11C will make it an offense if you introduce a person to a trafficker, and if you know or have reason to believe that the person intends to procure or consume drugs and the trafficker is likely to supply them. One example would be student offers to introduce friends to a trafficker to buy cannabis. Student himself does not take the cannabis, did not take part in the transaction, but he facilitated his friend's drug consumption. We have to try and deter such conduct. Section 11D1 will make it an offense if you were to teach, instruct, provide instructions to another person on the carrying out of drug activities. They could activities like consumption, cultivation, manufacturing, trafficking, importing and exporting. Knowing or having reason to believe that the person intends to carry out such drug activity. Sections 11C and 11D1 will have a mandatory minimum imprisonment sentence of 2 years for subsequent convictions and a maximum imprisonment of 10 years for, there will be no mandatory minimum for the first conviction. Now, supposing the perpetrator has no knowledge of the recipient's intention to commit a drug activity, nevertheless, the perpetrator has still caused harm. He has spread information on the carrying out of drug activities. So Clause 3 will have a Section 11D2, which will make it an offense to disseminate or publish information on the carrying out of any drug activities, those which I mentioned earlier. So this can cover a range of behavior from the irresponsible, like putting out information, posting information on how to manufacture drugs. And if you put it up on social media, where others can see it, to the downright malicious, like trying to teach, influence friends into taking drugs with one. And I think we have to try and stop such behaviors. Section 11D2 will impose a maximum imprisonment of 5 years. It could be a fine of up to $10,000 or both for first-time convictions. If there are second or subsequent convictions, there will be a mandatory minimum sentence of 1 year. Now, obviously, when you criminalize with this framework, you need to provide a proper set of defenses. So defenses would include legitimate purposes like administration of justice, science, medicine, education, art. So if you did this for purposes of any of those, then there would be exemptions. And subsidy legislation will set out the scope of authorized activities which will not be caught by the contamination offenses I just spoke about, and Clause 20 provides for that. Now, Clause 3 introduces new offenses. This is aimed at better protecting our children. So if you look at Section 11B, if an adult possesses illicit drugs and then knowingly or recklessly leaves it within the reach of a child, access of a child, that would be an offense. If an adult permits a child to consume drugs which are in the adult's possession, or does not take reasonable steps to prevent that from happening, that will also be an offense. The child is under 21. One example, October 2016, about 2 years ago, we had 2 young children, aged 2 and 4. They accidentally consumed their father's drugs, fell unconscious, and they were rushed to A&E. So the new offense will carry imprisonment of up to 10 years for first-time convictions and a mandatory minimum imprisonment of 2 years for subsequent convictions. We will also mandate, moving on to a different point, that parents and guardians of young drug abusers, where the young drug abusers are under CNB's supervision order, the parents, guardians must attend drug counseling. Clause 19 will provide for this. At present, parents and guardians are required to attend counseling, but some parents persistently absent themselves. CNB will, even after the new legislation comes into force, understand their context, try and understand why they don't want to come, and will use these powers very sparingly. But as a last resort, if the parents and guardians refuse to be involved in their children's counseling without reasonable excuse, then they can potentially be exposed to charges. When there is a young drug abuser, the impact is on that person, it's on the rest of society. It cannot just be the state's responsibility. The parents must bear some responsibility too. And they must come in and try and help. State provides the counseling, so they should come in there and take the counseling and see how they can help their children. Next, let me move to hair analysis and oral fluid testing. In 2012, we introduced hair analysis in the MDA as an alternative drug detection tool. Now, urine tests are able to detect only drugs that have been consumed within the week. Hair analysis goes further back. It can detect drugs which have been consumed earlier. Hair analysis now applies to monitoring of those under supervision. HSA, in its research science, has enhanced the effectiveness and reliability of hair analysis. So we will expand the use. Clause 18 gives the Director CNB the power to subject an abuser to rehab and supervision based on a positive result of hair analysis. So if you have test positive on hair analysis, you can be directed for rehabilitation and supervision orders. If a person fails to provide hair specimens, then he or she will be faced with the same punishments and liabilities as a failure to provide urine specimens. So these persons, if they intentionally refuse to provide the required specimens for testing with no reasonable excuse, then they can face charges. We are also introducing the use of oral fluid, saliva, to test for drug abuse. This is clause 15 of the bill. We a new section 31B. So enforcement officers can require a suspected abuser to provide oral fluids for the purpose of testing. Punishment can be a maximum of 2 years imprisonment, 5,000 fine, or both if there is a failure to provide. But the testing of oral fluids is only for the purpose of immediate, effective, efficient screening of suspects, particularly in the context of a mass raid or large crowds. Officers can then prioritize individuals who can require further hair or urine testing. Oral fluid tests will be an efficient method of screening. They will not be used for prosecution or emplacement on rehab or supervision. So they are a screening test. So we will continue to rely on urine or hair tests for purposes of a rehabilitation order, supervision order. Those are the aspects in which the Act is proposed to be changed in terms of increasing the powers, enforcement powers, or adding in some new offences. Now let me move on to the rehabilitation aspects of the bill. Drug abusers today who are arrested for the first and second time go through rehabilitation, which is mandatory in DRC. We call it DRC 1, DRC 2 for the first and second times. It's done through orders made by the Director of CNB under Section 34 of the MDA. DRC 1, DRC 2, there is no criminal record. The long-term imprisonment, or LT regime, was introduced in 1998. That targeted hardcore abusers who at that time formed 3/4 or more than 3/4 of the abusers who were being arrested. The purpose was to punish, but also to deter their drug use, because everything else has been tried. It was not possible to keep them away from drugs, and they were getting into drugs and they were contaminating others, and the problem was spreading. So it was to protect the public from abusers who turned to crime to feed their drug habits as well. So third-time abusers faced a mandatory imprisonment of 5 to 7 years and 3 to 6 strokes of the cane. Fourth time and beyond, 7 to 13 years in LT, it's LT2, 6 to 12 strokes of the cane. So from the beginning of the LT regime, together with other efforts on the enforcement side as well as the rehab side, the drug situation in Singapore has improved. The number of drug abusers arrested each year in 1996, roughly just under 6,000. to now slightly over 3,000 in 2017. So you can say it's about halved, which is, as I've said in other fora, quite a remarkable record, because all things are not equal. Because people's ability to afford drugs has increased, the amount of drugs being produced in the region and available internationally has increased. So all things being equal, the number of arrests should have gone up, not gone down. So it is a testament to the way CNB has worked, but it's not just CNB, the entire framework has worked to help our people keep off drugs. Education, prevention, a strong enforcement, an efficient CNB, an efficient legal framework, all have worked together. And the strong support that has been given both in this House and outside by the public for the stand we have taken. At the same time, over these years, Singapore Prison Service, or SPS, and SCORE have stepped up support for abusers. They include high-intensity psychology-based programs, especially for those with a higher risk of reoffending. They've also given skills training and work programs. And in 2014, we introduced the mandatory aftercare scheme. So we target the higher risk offenders, and they would be given compulsory structured programs even after they were released. Because after they are released is when they are at highest risk. And throughout this period, with the evidence that we have been collecting, we have been studying how to bring our recidivism down even further. And our assessment is that for pure abusers, we can now afford to shift the balance quite decisively and focus more on rehabilitation as opposed to detention. Long periods of detention, we all know, can obviously affect the abuser's employability after they are released. They are in for 7 years or 12 years or 13 years. When they come out, their ability to reintegrate back into society, their ability to hold down a job, there is a lesser ability, right? So really the question is, how do you strike the balance? What is the risk of allowing them into the community without long-term detention versus the consequences of keeping them in long-term detention? In 1998, we said, looking at the numbers and looking at the way the problem was growing, we have to go for long-term, and one or two other number of significant factors then too. Today, looking at the numbers and looking at the profile of detainees and looking at how we are managing, we think we can afford to take the risk the other way and let them out from DRC into society faster without going the long-term detention route. Really the answer as to where you strike the balance depends on a variety of external factors. Our view is that the situation has now changed compared to 1998. So SPS has been studying this. Our 2-year recidivism rates for LT inmates are encouraging. The recidivism rate for the 2015 cohort is 27%. That's down from 35% for the 2008 release cohort. Significant. But unfortunately, the 5-year recidivism rates for LT inmates remains very high at over 60%. What that means is within 5 years of their release, 6 out of 10 of the LT inmates will be back in prison. Addiction is a complex problem. Staying clean is ultimately dependent on a variety of factors, including the resolve of the abuser. But it's a difficult journey for the abusers. They become, often they become estranged from their families. They're estranged from the communities, the workplace. It's harder for them to reintegrate once released. a number get back into bad company on drugs, and then they get rearrested at various points. The cycle repeats itself over and over again. So we have decided let's try and distinguish between those who only consume drugs, I'd call them the pure abusers, from those who also face charges for other offenses. For example, trafficking, property offenses, violent offenses. So if they have abused drugs and they have committed some of these other crimes, we put them in one category. We put those who only abuse drugs in one category. For the second group, those who consume drugs and commit other offenses, they will continue to be charged for their drug consumption offenses as well as the other offenses. And if they are liable, they will be sentenced for LT. For those who only abuse but do not have any other criminal offense, that means they only consume drugs, and they admit to their drug abuse, then the general approach, regardless of the number of times, would be that the Director CNB will make the appropriate supervision or detention order and channel them into the rehab regime. So this group of abusers may also include those who have minor consumption-related offenses like possession of drug-taking utensils or possession of small quantities of drugs. If AGC agrees with CNB that there is no need to charge the drug abusers for these minor offenses, then these persons will also be channeled to the rehab regime. This will be conditional on the abusers admitting to their drug offenses. If they deny their drug abuse despite the evidence, that means they have really not accepted the need for rehab, and then they are likely to be charged in court if AGC concurs. These changes, as members will appreciate, are quite significant. Around 50% of LT liable abusers could now be channeled to the rehab regime. That means 1 out of every 2 of those who are going into LT could now go into a pure DRC regime. And really, to benefit as many persons as possible, CNB, with the concurrence of AGC, will generally not charge abusers who meet the criteria I have explained from tomorrow, 16 January, on the assumption that the bill is passed today. We also want drug abusers to come forward voluntarily for rehab. So moving forward, drug abusers who voluntarily submit themselves to CNB will be considered for shorter detention in DRC, but we will do a risk analysis, but based on that they can and will be considered for shorter detention. The abuser will still need to undergo operational and risk assessment before he or she can be considered for this. And all abusers will be given 2 surrender opportunities in their lifetime. These are administrative under the MDA. I will now highlight the key features of this enhanced rehab regime. In general, first-time drug abusers assessed to be low risk of further abuse will be put under the Enhanced Direct Supervision Order, EDSO. That's a non-custodial supervision order with compulsory counseling. A case manager will provide dedicated support to these persons and their families. Higher risk first-time abusers, as well as repeat abusers, will undergo intensive mandatory rehab in DRC, because that's a secure environment run by the prisons. It maintains strict discipline. The interventions will be based on the assessed risk and needs of the abusers. These will include psychology-based correctional programs, So in order to correct it, you need to target the underlying attitudes and drug addiction issues. So that's one set, psychology-based correction programs. Second, we will also run family programs so that, in the sense that they will be taught how to have a better relationships with their loved ones, because by and large, a significant number would have very strained relationships. We will also give them skills training and employment assistance. This is to improve their employability upon release. Third time and subsequent drug abusers, as the prisons will be introducing DRC-3, DRC-4, the periods will be longer than DRC-1 and DRC-2. Clause 18 of the bill increases the maximum period of detention for rehab. It will be increased from 3 years now to 4 years. That will apply to high-risk repeat drug abusers who are going to require a longer period for rehab. Those who are assessed to be ready to be discharged from DRC to move into community-based programs. There they will be put into halfway house. It's a day release scheme from a community supervision center, or they could be allowed to go home with electronic tagging. So DRC, from DRC released into a CBP, community-based program, where you could be leaving in the morning, going and doing your work, coming back at night, really to keep you in as safe an environment as possible. I just opened last week the first prisons run halfway house, but there are other halfway houses. We work with partners and we financially support them as well. They work quite well. So after community-based program will be the supervision phase. During this phase, the abusers will be, ex-abusers hopefully, will be required to report regularly to CNV for urine and hair testing. Prisons, SCORE and CNV will also work with community partners. This is to try and help the abusers in areas such as job training and support, casework, counseling, and befriending. We have been devoting a lot of resources to the post-release support, and that is why we feel confident that we can move ahead with this. And the risk of recidivism is highest in the first 2 years. Then, I've given you the figures for 5 years. They can be clean for 5 years, then the recidivism rates drop quite sharply, particularly for those who are able to keep a job. The current supervision period is 2 years. So I've decided that that should be increased post-release. And Clause 18 will increase the maximum supervision duration to 5 years. So you're released, but you're subject to supervision for 5 years, which hopefully will help in keeping you clean. So the changes taken as a whole mean that if you have abusers who only consume drugs and admit to their drug use, they will undergo shorter but more intensive rehab in DRC as opposed to LT. And then they will be placed on CBP, community-based programs, and then they will report for a longer period of supervision of up to 5 years. During the period of CBP and supervision, the abusers will be encouraged to hold a stable job, strengthen their relationship with their families, and build better ties with the community. So really the hope, the aim is successful reintegration back into society and to reduce reoffending. The journey is not an easy one for abusers, but we want to give them the best possible chance, and we want to motivate them to stay drug-free and also put in the infrastructure, as in a longer period of supervision, which can help them in the longer term. So clauses 13 and 14 gives Director CNB the power to require abusers who have completed their rehab, supervision or imprisonment to still report to CNB for urine or hair tests when required. If the person fails to comply, then it's an offense, and the penalty could be an imprisonment or fine, or both. With the changes and the changes we implement, we obviously will track the recidivism rates very closely, and if necessary, we will adjust our approach or change. What are the consequences of this? A very substantial number, maybe up to 1 out of every 2 persons who are arrested who would have gone to LT could now go through this rehab route that I have sketched out. Some will still be charged in court. As I mentioned earlier, those who could be charged would be persons who face other criminal charges or deny their drug use. Sentencing trend for first-time drug consumption is usually 6 to 8 months. With 1/3 remission, the period in custody will come down to 4 to 5 months. Now that is shorter than detention in DRC. So those charged and punished with imprisonment should serve a sentence that's more reflective of the strong deterrent stance against drugs and should not serve a period which is less than what a person in DRC will serve. So clause 16 provides for a mandatory minimum sentence of 1 year for first-time conviction for drug consumption. Previously, there was no mandatory minimum. The mandatory minimum sentence will also apply for first-time conviction for failure to provide a urine specimen or hair specimen. Now, we have also reviewed the antecedents which count towards enhanced punishment for second-time abusers who are convicted in court and LT. For abusers convicted in court, clauses 16 and 17, they will receive enhanced punishment of LT whenever it's applicable if the current offense for which they are convicted is one of drug consumption or failure to provide urine or hair specimen, and the antecedents include any of the following: a previous conviction for drug consumption, a previous conviction for failure to provide urine or hair specimen, a previous admission into an approved institution for rehab, and a previous conviction for drug consumption under the SAF Act. I will now briefly summarize the other amendments, which are really of an operational technical nature. Clause 5 repeals and reenacts Section 13 to clarify that the punishment for abetting an MDA offense in Singapore from outside of Singapore carries the same punishment as a primary offense abetted. Clauses 7 and 8 remove the powers of the Vigilante Corps members for MDA offenses, as they are no longer involved in drug operations. They also extend the powers of special police officers to conduct search and arrest for MDA offenses. They are often involved in ground patrols, operations which may entail the arrest of drug offenders. Special police officers will include full-time national servicemen and WAR-NS men during their periods of service. Clause 2 sets out the different categories of transport devices to make clear the different types, including unmanned craft, that enforcement officers may seize in the course of investigations. Clauses 6 and 8 define the related powers of search and seizure. Clauses 9 and 11 set out the processes and requirements for forfeiture, return, and disposal. Clause 13 allows appointed SAF enforcement officers to collect urine specimens from persons subject to military law if these persons are suspected abusers. Now, the current practice for suspected abusers is to be committed by Director CNB to a specified place for a maximum of 7 days for medical examination and observation. Clause 18 codifies that. It also extends the initial period to which a person may be detained for rehab and the period for which they may be further extended. This may further be extended from previous 6 months now to 12 months. This is really to make it more streamlined, where the detention order of every single abuser in our institution needs to be extended every 6 months. But the total detention will not exceed 4 years, as I've stated earlier. Lastly, or finally, Clause 20 provides the Minister with regulatory powers to provide for the supervision and aftercare of persons who have been convicted under the SAF Act for drug consumption or for failure to provide urine or hair specimens. So we intend for these groups, like all other groups, to undergo post-release supervision to encourage them to stay drug-free. Mr. Speaker, I beg to move.